Edify means to enlighten, encourage, and uplift individuals, intellectually, morally, and spiritually. That's exactly what our EDIFY Podcast guests do, as they share practical wisdom on living our faith in public. I'm Mary Fiorito. Thank you for joining us today. Welcome to the EDIFY Podcast. Our guest today is Kellie Fiedorek. She serves as Senior Counsel and Government Affairs Director for Alliance Defending Freedom, working to protect First Amendment freedoms, the sanctity of life, and the right to privacy. Welcome, Kellie.
Thank you, Mary. It's great to be here with you.
Thanks for being with us. So, Kellie, you are with Alliance Defending Freedom, which is well known in the country for taking on cases that often find themselves in the media. When you were in law school, was this something that you had hoped to do, to be so involved in cases that were both controversial and highly public?
It was certainly a dream to work for ADF and to work on cases involving, defending our fundamental freedoms, defending the sanctity of life. And oftentimes in our culture that we find ourselves in today, those do tend to be a bit controversial, but it's just a real blessing and privilege to be able to work on such important cases that impact so many Americans' lives.
Well, let's start with a sort of fundamental notion that's often thrown out, especially on social media, when we're talking about things like the right of free exercise of religion and privacy rights, is that there's a separation of church and state. There's so much misunderstanding about that statement. And can you explain to our listeners where that phrase comes from? I know it's not in the Constitution, where it comes from, and what its original meaning and intent were.
Well, the Supreme Court has been very clear about what the Constitution says, and that is that the government cannot infringe on Americans' fundamental freedoms. We each have, and it's really rooted in our human dignity,
right,
that freedom to be able to live, to work, to speak, consistent with our convictions without the government infringing on that or dictating what we should think or what we should believe or how we should speak.
Right.
And so really what the Constitution, what the First Amendment and the Free Exercise Clause protect is to ensure that the government in no way infringes on individuals or on agencies or churches or businesses who are run and operated by individuals who each have that conscience.
Right.
So it's really meant as a safeguard to prevent government intrusion into the lives of American people.
And particularly religion.
Absolutely.
As many Americans don't know, actually, the phrase separation of church and state comes from a letter that Thomas Jefferson wrote to the Danbury Baptist Convention, or the Danbury Baptist Church Group in 1802, to assure them that the United States has a wall of separation of church and state that would protect the congregation from being imposed upon by the government or directed by the government to do that. So it was to assure religious organizations and religious denominations that no, the government here is not going to interfere with your religious practices, your religious beliefs, what you may do in public as a religious person. But that whole phrase gets turned on its head. And I think many people understand it now to mean that you can't do anything religious in public.
Right. And the whole entire purpose, you're absolutely right, was to ensure that, one, there was no government-endorsed religion. But ultimately, that was to ensure that everyone had that freedom. I think a lot of Americans think that our freedoms come from the government. They don't. Our freedoms are rooted in each of us in our human dignity, because
they're
we're
natural rights.
They're natural rights.
That come from
the
God.
Government's duty is to protect those freedoms and to ensure that they're not infringed on, so that each of us has that freedom to explore the meaning of life, to pursue our religious beliefs, and then to order and live our lives consistent with those
our own
convictions,
consciences,
with
right.
our own conscience. Exactly.
Right. Well, I know this wasn't your case, but can you speak a little bit about the most recent sort of religious liberty case that the Supreme Court decided involving a football coach who had been praying with his team? It was he coached at a public high school, had been praying with his team regularly. It was optional, but he had been praying with the team, and sometimes before the game and sometimes after the game. And finally, he did this for years, was finally reprimanded. He stopped doing it, but what he continued to do was to go to the 50-yard line after the game was over and say a prayer. And he did that on 3 separate occasions, and then he was terminated from his job. And the court ruled that that was a violation of both his free exercise and free speech rights. But boy, did that entire fact pattern get twisted in the media, didn't it?
It really did, and it's not an isolated occurrence where we're seeing people who are trying to live their lives and pursue their vocations and live and work consistent with their convictions. And rather than seeing the government, both at the federal level and the state level, protect people like Coach Kennedy and respect their ability to it's truly an exercise. It's supposed to be an exercise of our conscience. They're trying to silence anyone who they feel disagree with current government orthodoxy. And really that should frighten all of us, no matter where our beliefs are, because, history comes and goes. Some beliefs are popular, some aren't. And really the purpose of the First Amendment is to protect the minority views, the minority beliefs, so that everyone has that freedom to live and to work consistent with their convictions.
Right. And, the analogy I try to make is that, the government can't tell you not to be a religious person in public. So if I work at the post office and it's Ash Wednesday, I can't be told not to wear my ashes on my forehead. And, that's just kind of a simple example, but, that's the kind of freedom that we have in this country. Where in other countries, if you do work for a government entity, you can't have any outward expression of your religious beliefs.
Well,
right?
and I think oftentimes people think that your religious beliefs only stick with you on Sunday. They forget that they inform your life, Monday through Saturday as well, whether you're at school, whether you're at work, whether you're at home, whether you're at the grocery store. We should be able to express and to live consistent with the very faith that inspires and drives our lives.
Right. And, I'm an allied attorney with ADF, as you know, and I remember that very first time I went to an ADF training, and, we talked about this, living your faith in the public square and how important it is.
Right.
And, particularly as Christians, we're not supposed to keep our light under a bushel basket. We are supposed to share, but that, the founders put it first because they considered it the most important freedom. Freedom of religion is the first.
It's bedrock. It's bedrock to everything else.
And it is fundamental. So therefore, it receives the highest level of scrutiny constitutionally, because in order to infringe upon that freedom, you've got to have a really, 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 really good reason to do it, right?
Right. And we're really, one thing, Mary, it's been really on my heart lately is that the United States is truly sort of the last country that is so committed to protecting free speech, to protecting religious liberty. Many countries aren't doing that. And so we're at a crossroads. We're seeing the government increasingly target those beliefs. So if we as Americans don't stand up and say, these are important, we want to cherish these. And I think part of that is explaining the good of religious liberty. Sometimes people don't realize, well, what's good that comes out of it? Well, if you think about all of the social welfare organizations, the adoption providers, the foster care providers, those who are serving the poor, the homeless, those in prisons, many of those entities are inspired and driven by their faith to serve the most vulnerable amongst us.
Right.
So protecting religious liberty has a very tangible impact. And you see when societies protect that, you see human flourishing. Societies that don't, you see people suffering. You see more war, you see more poverty.
And you see human rights abuses.
Absolutely.
Too. I mean, you look at China is probably the perfect example of that.
Yes.
Well, you were fortunate enough, and how privileged you were to be able to work on the Dobbs case, the case that overturned Roe versus Wade and Planned Parenthood versus Casey. Tell me a little bit about that. I mean, just like that would have been, I think, a dream come true for so many Catholic lawyers and Christian lawyers.
It was truly a humbling experience.
What was your particular role?
Alliance Defending Freedom served on the legal team with the Mississippi Attorney General's office to defend the law at the court. We were also involved in drafting the model legislation that Mississippi ultimately used to pass the law back in 2018.
So you were there from the very beginning.
Yes, from the very beginning.
When you were doing that, did you have an understanding that this is going to be the law that will then get Roe back in front of the court again?
We certainly were hopeful that it would. When we were drafting the legislation, we were really trying to find something that was strategic, that would strike at the heart of Roe and Casey.
Right.
And the law, there's three components to the law that were really important in terms of where the court has said a state can regulate abortion and protect life. One is the interest of the unborn child. Two is just the impact of abortion on women's health and well-being. And we know from the science and the data that certainly in the second trimester, the risks to women go up significantly.
Right.
And then third is just to protect and defend the integrity of the medical profession, which is another vital component. So we were certainly very hopeful that this law would ultimately challenge Roe and Casey, and it did. I mean, the court was so right in saying that those laws were egregiously wrong.
Right.
They have no basis.
Egregiously wrong from the beginning.
From the very beginning, from 1973, and for right reason. There's no basis in the text of the Constitution. There's no basis in the history of our nation's laws. In fact, in 1973, 46 states already protected life. Some of them even criminalized abortion at that point. So our history speaks to a protection for life and a support for women, not the opposite.
Right.
So no basis there. And so the court was absolutely right to overturn those and return that decision to the people and their elected representatives to pass laws that affirm that life is a human right, and that to find ways to comprehensively come around women and their families, to support them to choose full and flourishing lives. And, I think all of us in this country should be so grateful to Attorney General Lynn Fitch and to Solicitor General Scott Stewart, because they were bold. They didn't have to ask the court to overturn Roe. They could have just said, hey, uphold our law, but they didn't. They said Roe is wrong. And they were bold, and their courage to say, overturn this terrible decision that's hurt countless people. We owe such a debt of gratitude to each of them.
Why the 15-week? So, listeners, for those of you who aren't familiar with the Mississippi law that brought this case to the Supreme Court, Mississippi banned elective abortions after 15 weeks. Except for, I believe there was a life of the mother exception, but also I believe a fetal abnormality. So why 15 weeks? That felt like a kind of random number to me, because so much of Europe limits it at 12 weeks. Even Roe itself, talked about the first trimester. Was there a particular strategic reason for choosing that 15-week number?
Well, I think 15-week was particularly strategic because we recognized that once you get fully in the second trimester, where is the science and where is the data? A lot of the science was showing, certainly with unborn human life, at that point, they can definitely feel pain at 15 weeks. We know that they can hiccup, they can taste, they can move, they have a heartbeat. There were so many developmental components to it that were very clear at 15 weeks, and the science backed that up.
Right.
We also saw from the perspective of the woman and the impact abortion has on women, the substantial risk to her life, just this risk of death, as well as physical and emotional complications, go up substantially. I believe the risk of death goes up 2,000% once you get squarely into the second trimester.
Right.
Also, the procedure that is required for abortions once you get to second trimester is so brutal, as they tear the baby limb from limb. And really, for the medical profession, if you take an oath to do no harm, we should not be putting our physicians in a position where they are providing this horrific and gruesome procedure. Exactly. They're causing harm. So for all of those reasons, it made sense to really focus on that time frame, and also to push back on the viability test. The viability standard is such an arbitrary rule that the court gave us. Another reason why Roe and Casey were just so horrific.
Yeah, and Roe reads like legislation, doesn't it? Where the court lays out this trimester framework.
Right.
And there had been no evidentiary hearings at the trial court level in Roe. So, where they seem to have kind of pulled it out of thin air and were acting like legislators.
Right. And the viability line, that's changing. I mean, with the development of science since 1973, viability is consistently moving lower and lower. And that was something else we recognized, that if you have such an arbitrary line like viability, that really is not a line to determine whether a life should be protected or whether a life should not.
Right, exactly. And we in fact had another EDIFY interview and video with a pediatrician who is a neurodevelopmental pediatrician. So she treats a lot of babies. Once they leave the NICU, she becomes their doctor. There's a lot of babies born prematurely. But she was talking about the science that the court had available to it in 1973, where even babies at 34 weeks only had a 5 to 10% chance of survival. Now, those babies often don't even go to the NICU. They just go straight home. So we have just made, advancements that are, just wildly ahead of where the court was back in 1973. And it was about time the law caught up with it, right?
Absolutely. Yeah. Absolutely.
Well, Kellie Fiedorek, thank you so much for all that you are doing to edify Americans on the Constitution and on their God-given rights to practice their religion. We wish you all the best, and thank you for being on our podcast.
Thank you, Mary, for having me.
Thank you for listening. To make it easier for you to listen to future EDIFY Podcast episodes, please make sure you subscribe over at Apple Podcasts, Spotify, or wherever you listen to your favorite podcasts. Thank you.